So when you're not in her office, so this is the thing. They give a directive that count 7 doesn't exist in law. So that they should amend it, change it, it doesn't exist. I still play to that same faulty law.
Yes, it was an error.
It was an error, big error. So I want them to correct
that. That was one of the motions we asked. That appeal should be set aside.
That's right.
And it has been
some of the errors and mistakes in
that judgment.
The judgment.
And the reason why it should give you a closer date.
Absolutely.
A closer date to the motion.
Which
are the things that you listed. The fundamental error.
It's on and on at the main judgment. It's on page 22, page 25, page 26, page 27. The main thing I would have has now repealed laws and not found any prosecution. They still remitted back repealed laws to the High Court.
For the Federal High Court to correct it.
It's true. To correct it. They have not corrected it. So I had to come back here.
For them to correct it?
Yes, they don't correct it because it's an error on the face of the record.
And there are some directives were hanging. And it was not compliant.
Yes, especially with count 7.
And that was the reason why it should be clear.
Absolutely.
Why it should be.
I need to know because how could we like a judgment instead of like count 7? So when you're not in her office, so this is the thing. They give a directive that count 7 doesn't exist in law. So that they should amend it, change it, it doesn't exist. I still play to that same faulty law.
Yes, it was an error.
It was an error, big error. So I want them to correct
that.
That
was one of the motions we asked. That appeal should be set aside.
That's right.
And it has been heard.
Nnamdi Kanu has presented 5 requests to the court. The Federal High Court in Abuja, where he's standing trial, he has presented 5 requests to the court. When did he present the request? Recall that the case of the prosecution was closed. Nnamdi was to open the case of the defense. He said he doesn't want his lawyers anymore, and the judge allowed him to defend himself. Okay? On one of the occasions when the matter was adjourned for Nnamdi Kanu to open his defense and call his witnesses, Nnamdi filed a motion on notice. In that motion on notice, he made 5 prayers to the court. So what are those 5 prayers that Nnamdi Kanu made to the court? We look at them in this video, right? Now, the first prayer that Nnamdi has made is for an order of the court expunging, that's removing, from the records of the courts, the purported plea of not guilty entered for him on 29th March 2025 for reason that same was obtained under deception, coercion, and in clear violation of Section 36 sub 6 sub A of the Constitution of the Federal Republic of Nigeria, and also in clear violation of the directive of the Supreme Court in his case that went up to the Supreme Court. That's prayer number 1. It basically saying, I made a plea of not guilty. You know, in criminal trial, you must make a plea, guilty or not guilty. When you say you're not guilty, it means that the court is allowed to move into trial to hear the case of the prosecution. If you say you are guilty, the court sentences you almost immediately. The prosecution will be called upon to make a summary of your case. The positions of the court will be brought in, and then you are sentenced summarily. But in this case, Nnamdi said, I am not guilty. So Nnamdi is saying that that plea that he even made, he made it as a result of deception, coercion, and in clear violation of the Constitution, because he was misled into taking that plea. Okay?
Share this video.
Number 2, he says, an order of court setting aside all proceedings conducted in this trial, because the proceedings were conducted based on a defective plea. He said the court should also set aside every other thing, scheduling of defense, witness summons, trial dates, and everything, because it was founded on a nullity ab initio. So he's asking the court to set aside all proceedings in the matter. Some lawyers will ask, is it possible? Me, I will answer by saying, we wait to see. Prayer number 3, Nnamdi is asking for an order declaring that the 7-count charge, Nnamdi is standing trial for 7-count charge, brought under the Criminal Code Act and some brought under the Terrorism Act. So he's saying, an order of court declaring the 7-count charge dated 29th March 2025, declaring that the 7-count charge discloses no triable offense known to law, and he has given reason, having been founded on repealed statutes. Nnamdi keeps saying, where is the law? Show me the law. So he's saying that in prayer number 3, that the courts should declare the 7-count charge as having disclosed no triable offense, because according to him, they are founded on repealed statutes. He has named the statutes here, the anti-terrorism statute, and also he has said that another reason for this prayer number 3 is that it is in flagrant disobedience of the Supreme Court's order for amendment of the charge. Right? Prayer number 4, Nnamdi is asking for an order striking out the charge in its entirety for want of jurisdiction, same being incompetent and void ab initio. We look at prayer number 5. In prayer number 5, Nnamdi is saying an order directing the immediate release, that is, directing his immediate release from custody, there being no valid charge pending before this court against him. So these are the 5 requests, these are the 5 prayers that Nnamdi has presented to the court in the motion of notice that he has filed. Right? Now, he has given 9 grounds to support the prayers that he's making. One of the grounds is that the plea of not guilty was procured from him, forced, right, under pressure, which renders the entire plea taking exercise a nullity. Number 2, that the charge is founded on repealed statutes. Number 3, that by the Constitution of Nigeria, no person shall be convicted of an offense that is not defined by a written law at the time of the commission of the offense. That the prosecution's reliance on repealed laws violates his constitutional safeguards. Right? Nnamdi, in his further grounds, also says that the court lacks jurisdiction to proceed on the charge that discloses no offense known to law. Finally, he says that he has been in custody since June 2021 without a valid charge, and that this is a continuing violation of his fundamental rights under section 35, 36 of the Constitution of Nigeria, and for this reason he should be set free and allowed to go home. So 5 prayers to the court. He has supported the prayers with 9 grounds, that is 9 reasons. Now, what's the law on this? What is the law on this? We look at it together. 1, Nnamdi is challenging jurisdiction, and in law you can challenge jurisdiction at any point during the trial. What the law says, you challenge it before judgment. So Nnamdi has challenged jurisdiction of the court, because those prayers are basically challenging the jurisdiction of the court. So Nnamdi has challenged the jurisdiction of the court before judgment, and the law allows him to do that. Some persons will ask, why did you wait till this time to file this motion to raise these issues? The answer is simple. In law, once you are challenging jurisdiction, you are saying that the courts did not even have the power to try that matter in the first place, that everything that the court did is a nullity. So the law allows you to raise the issue of jurisdiction at any time before trial, at any time during trial and before judgment. Even on the day of judgment, you can stand up and raise the issue of jurisdiction if you are so sure about it. Even in the court of appeal, you can still raise the issue of jurisdiction. So there is no time frame or time limit for the raising of issue of jurisdiction, because jurisdiction is like foundation of the building. Without foundation, the building cannot stand. Without jurisdiction, no trial in law can stand. So that's the first legal implication of what Nnamdi has filed. Number 2, the danger, however, is if your motion fails, the consequence might not be sweet. In this case, Nnamdi is relying only on the prayers he has made in the motion paper. Recall that Nnamdi has not filed any defense. He has not entered defense. He has not called anybody in his defense.
Share this video.
What he's basically relying on right now is the motion that he filed, wherein he has raised 5 requests or 5 prayers to the courts. If those prayers fail, the danger is that the consequence might not be sweet. Right? 3. This is why most lawyers prefer not to put all their eggs in one basket. What you do, you enter the defense, you call your witnesses, you tender the evidence, and then also file a motion raising the issue of jurisdiction. More so, if in the course of trial the judge had made a ruling on a no case submission and had said that you have a prima facie case to explain to the court, lawyers would then prefer to go on with the defense and also raise the issue of jurisdiction, so that you don't have all your eggs in one basket. You have, if this one fails, this one, might succeed. This one fails, this one succeeds, and you still achieve what you wanted as a lawyer, to have your client, discharged and acquitted. Now, this is where most of us think that Nnamdi Kanu should have allowed the services of his lawyers in this matter. They had been with him from the beginning. So many lawyers, Maxwell, Ejimako, remember there was Ejiofor. I think Ejiofor started that matter, that fair, handsome gentleman. He was there. Lots of lawyers have been here. Zokome was here. And finally, he got the services of Kanu Agabi, Senior Advocate of Nigeria, former Attorney General, very intelligent, seasoned lawyer, highly respected across the spectrum.
Share this video.
He got him to his defense. He also got Onyechi Ikpeazu. Onyechi Ikpeazu is one of the most intelligent lawyers Nigeria has today. Talk about election petition. Onyechi Ikpeazu handles election petition for sometimes 5 governors at the same time, flying here and there, and you know what that means. He's also very sound in law generally. So now they had the services of these persons and other persons. Some of us believe that he should have allowed them to continue with the trial, with his defense to the end, right? But Nnamdi chose to defend himself, and that's right, that's fine. One has to respect his decision. I respect his decision to defend, himself. Nnamdi is convinced that he is right in his decision. That's cool. We have to respect that. I respect that. Okay? We wish him the very best as we await the decision of the courts in this matter.